they don't make those arguments explicit in when they actually file a claim, like file, for their case against you. They're not going to explicitly make those claims.
Usually they claim it simply as this court has jurisdiction over this issue. It's a simple checkbox sentence. They're claiming that there is nothing wrong whatsoever with asserting the impositions that would result from jurisdiction, yes. Or at least to the level of hearing it. Now, they may not be proclaiming that the court has jurisdiction to enforce an order, but they are at least saying as much as to hear the case. Now, I think maybe there's an implicit part of that that says if you can hear a case, you can punish the case or whatever, but I don't know. I don't know that to be true either way. Let's put it that way.
From this conversation, at one point, and I can't remember exactly where it was, but at one point I started to get the idea that what you're talking about, it seems to indicate that you're thinking that there is potentially some circumstance where all of these things could be satisfied. So what would be an example of a circumstance where territorial jurisdiction could be satisfied? The reason why I go for territorial is because my understanding is that, I can't imagine any way to prove that.
Saying you have territorial jurisdiction, the reason it would be wrong, whether it's right or wrong, the reason that it would be wrong is outside of the topic of territory. Okay, so if we don't have jurisdiction, it is not because of an issue of territory. So it's a double negative. I'm doing a double negative. Forgive me. That's the only way to really do it. So to say that there is no territorial jurisdiction issue, if there is an issue with jurisdiction, it is not in the subtopic of territory. And you're saying, is it ever possible to prove that there is nothing wrongful about imposing when looking only at the issue of territory? Okay? And that could be satisfied. The one way that's easily satisfied is military. Military kind of sidesteps a lot of this in the sense that military jurisdiction has no boundary limits. So the territorial jurisdiction is true globally. You know what I mean? You can easily say that when somebody is brought up when somebody who actually they have jurisdiction over because of, let's say, a voluntary contract of enlistment, it's outside of the issue of territory. If it is wrong for them to exert jurisdiction, it is outside the issue of territory. It also, incidentally, if they have a valid, voluntary, let's call it, enlistment, it's outside of the area. For some, if the issue isn't religious in nature or something like that, it's probably outside of the area of subject matter jurisdiction. So they probably would be easily showing that it's not wrong for them to impose upon an accused serviceman, I guess you call it, right? That really doesn't hold as well with someone who's not a serviceman. And if you ask them for evidence of jurisdiction in military, they'll pull it right out of that folder and give you a copy.
Exactly.
Now, again, the presumption, of course, is that it's a signature and no one had a gun to your head and all that kind of weird stuff, right? But you'd be kind of pissing up a rope to try to argue that you've been in for years and it was all involuntary. Okay, cool. So let's see.
Okay, so outside of the military would be difficult. Somebody raised the question about, say, like you're driving your car and you rear end somebody, you damage their car, and that they are now a plaintiff bringing a complaint against you. Is that something that you think they would actually be able to satisfy everything?
Okay, so let's say I'm injured and I want to enlist the state and bar to help me get justice. All right. A little bit wrongful that they have a monopoly on it, but that's for the victim to figure out, right? Not the guy who did the injury. That's the victim's problem if it was voluntary or involuntary or monopolized. So the issue of territorial jurisdiction is then, from their perspective, of course, am I in the correct subdivision of the bar that it is not wrongful on territorial grounds to impose? It might still be wrongful, but on the territorial question only, would it be wrong for this court to act? Now, keeping in mind, of course, that the only concern in question is subdesignations, states, municipalities, countries, things like that. And all they have to do that is show physical location, of course, pretty easy, and then show that the bar is in kind of a unanimous opinion that, again, we're into opinions, though. But my claim isn't. My claim is about the opinion of the bar, right? My claim is that the body politic has designated this territory as being the one to judge that issue. That doesn't make it jurisdiction, though. That doesn't make it not wrong. It just makes it not wrong based upon local location. Not wrong for that court, I should say. Personam jurisdiction, I would satisfy in that case by proving that I had an injury that was from an action by the person accused, and that the accused had been given the opportunity to make it right and did not. And furthermore, that he was not in negotiations about the level of the injuries. He was in simple non-payment, right? That would be a kind of a requirement, right?
That makes sense.
It's not that I just sued him right off the bat. I had to actually say, here's how much you owe me. And he didn't come back and say, I don't owe you that much. I owe you this much. I can't take him to court in order to shortcut the negotiation process. You're taking him to court to show an injury. Again, there's a whole administrative law thing that comes into play there, but let's not get to that. Let's presume it happened. Now, subject matter jurisdiction is, again, does the bar designate the specific court or clerk or group of people as being the ones who address the issue at hand? Now, one of those questions on that one is, in most definition documents, most forming documents of courts, they actually designate that the courts only handle adversarial issues. So one of the check boxes is, are there two adversaries, actual adversaries with non-hypothetical injury involved? And I could check off both of those. I could say, he is not an imaginary person. I am not an imaginary person. And the injury is not imaginary or hypothetical. The injury is this damage evaluated at this much, blah, blah, blah. The in rem jurisdiction involved, I could prove by showing that the automobile, now it gets a little tricky. It gets dicey because the state holds eminent domain issues. For the purposes of all this, let's pretend I own it, free and clear, and no one argues. And I would show that the damage was to my property, not to somebody else's property. I am putting this under this property under the court's judgment. So it has in rem jurisdiction over the property. It gets a little funny because we're not talking about the car anymore. Let me think about that. That's not in rem jurisdiction. I actually have to show that the money in question is under the jurisdiction of the court. No one ever does that. It's never done. So if you're ever sued, I wonder how you could bring this issue up by showing that the other side has not proven that the money is under the jurisdiction of the court. Because one thing is the personam jurisdiction. That is the holding him, dragging him into court and making him answer and so forth. The other is issuing an order that affects cash. That's probably why they are so remiss in addressing how to pay. Because they don't want to proclaim that you have to pay in Federal Reserve notes, because you can then challenge the in rem jurisdiction of the court over Federal Reserve notes. If they leave it nice and vague, then what do you have to challenge? You have to get clarification first, and they don't like doing that. So the presumption, I bet, is leveraged on the idea that, well, it didn't come up, so there must be some sum of money that is under the jurisdiction of the court that is currently in the control of the defendant or the accused or whatever, the sued, and it's just sidestepped in its entirety. So the in rem question is kind of dodged. I bet I could do something with that if I actually I had somebody coming up and I'd make an issue of the in rem jurisdiction of the judgment sought, because they're usually seeking money, right?
Right.
Like, okay, so the prosecutor has evidence that the money in question that he's asking to be transferred to him is actually under the jurisdiction of this court. Wow. And then we could also do that, though. There's nothing stopping that at civil cases. What am I thinking? Interesting. You sparked a really interesting thought. I'm going to have to follow that one through one day. We hear about people coming up and with asking judges and courts, what is a sought judgment? What is it you're actually physically asking me to do? And they really have a fit. Like, are you physically asking me to give you silver? Are you asking me to go get Federal Reserve notes? Are you asking me to write a check? And if you're asking me to write a check, are you asking me to make sure that the bank will give you money in exchange for that check? Making them pin down to what they're ordering as a judgment is really, really putting them in a hot seat.